So when it comes to the exam preparation strategies, I think that we can't talk about how you should be preparing for the final exam without developing a keen understanding of the grading practices, right? You can only prepare for a final exam once you truly understand how your exams are going to be graded. Why is this important? Well, we see that lots of times law tends to be a very special discipline in a way. So we see that lots of people will start studying law and they will use the same methodology to study law as they would do with other social sciences. So a lot of people who start taking legal exams have this impression that the success on the legal exam is going to be a function of their ability to memorize legal rules, right? The more time I spend studying, the more time I spend on memorizing different legal rules, the better I'm going to do on my exam. Now, this assumption is very flawed, and this assumption is actually what separates an average grade from an excellent grade in a legal exam. If you think about the grading process, I think there is one constant across different legal subjects and for better part across different legal cultures as well. Your professors are going to be testing you on two key skills. Number one, have you recognized all the legal issues present on your exam? And number two, did you actually apply the law to solve those issues? Now, this might sound very straightforward, but in practice, it's anything but. In practice, it's very often the case that students will just forget to actually apply the law to the facts of the case, even though they will reach a very good conclusion. So let's go a little bit slower and let's take a look at a few examples to illustrate this concept and to show us how grading practices should affect our exam preparation strategies. The example I'd like us to take a look at today is from my international commercial law class. Now, I don't want you to focus too much on the law itself or on the facts of the case I'm about to present, but I'm going to briefly walk you through the exam itself and some of the legal rules applicable in order for you to be able to distinguish between an excellent exam answer, an average exam answer, and a potentially bad exam answer. So let me tell you a few things about this case. In this case, we had an international commercial dispute, a contract dispute between a French seller and a Swedish buyer of luxury clothing items. So as you can see from this case, and if you want, you can pause the video to read it. So this is a short extract from the exam text itself. In essence, the parties negotiated a contract for sale of goods, and the Swedish buyer actually purchased some shoes from a French seller. Now, we also see in this particular case that the CEO of the Swedish company purchased some of these shoes for her own personal use, and that's about as far as the facts actually go. Now, we see that the question which was raised on the exam is whether or not CISG is applicable to this case. What is CISG? CISG is the United Nations Convention for International Sale of Goods, so it's basically an international convention which is applicable to contracts for sale of goods. Now, CISG itself tells us when it's applicable to a certain dispute. If we take a very brief look at the rules which we find in the CISG, the relevant rules for this particular exam, we will see that Article 1 tells us that CISG always applies if we have two parties which enter into a contract for sale of goods and they come from the states which have ratified the CISG. On top of this, we also find some criteria in Article 2 of the CISG, which says that CISG will not be applicable if the goods which are purchased for personal, family, or household use, unless the seller at the time before or at the conclusion of the contract neither knew nor ought to have known that the goods were bought for any such use. So long story short, CISG is applicable whenever there is a contract for sale of goods between companies which have a place of business in states which are contracting parties, and the goods were not purchased for personal use, or in the case that they were purchased for personal use, the seller did not know or should not have known of an intent to use the goods for such personal use cases. So that was a very brief summary of both the facts of the case and the actual law which is applicable, which you need to use in order to resolve this dispute. But once again, you can read both the description of the case and the applicable law but don't focus too much on it. I just want you to get the basic idea of what the correct answer should be. So why did I start by saying this? Let's take a look at some of the exam answers, and let's compare three different categories of the exam answers. So let's assume that the correct answer, quote unquote correct answer in this case, is that CISG is applicable. This convention is applicable because different criteria, which we just saw in Article 1 and 2, are fulfilled. Now, one could simply say, yes, CISG is applicable, and such answer would, in all likelihood, be correct. So you would reach the correct conclusion. But still, if we see that this particular exam question was graded with about 15%, as somebody who is grading this exam, I would be very hesitant to give this person any points at all. We see first and foremost clearly in the way that I phrased the question that the candidate was expected to elaborate why CISG is applicable. Now, I included this wording, why, as means of helping students on the final exams, that they shouldn't forget to explain why CISG is applicable or not. But on many legal exams, you will not have such a prompt. You will simply receive a question, and if you respond with an answer which doesn't really include any analysis, which does not explain why in this particular case you have reached your conclusion, then you're in all likelihood not going to get any points at all, even if the conclusion which you have reached is entirely correct. So that's the first and somewhat obvious example, but it just underlines how important the analysis of the legal issues is. So it's not about reaching the correct answer. In legal disputes, very often you will be able to argue for both sides of the dispute. It's all about how you actually reached your conclusions. So let's take a look at another exam answer then. CISG is applicable in this case. The parties come from different contracting states, Sweden and France, and no exclusion criteria are applicable. Taken at its face value, this is once again correct. And we do see that there is a little bit more analysis in this answer. However, this analysis is not thorough enough. So we saw in the wording of the CISG, we saw in the text of the convention itself, that there are several criteria which should be applied to determine whether or not it's applicable. And in the present case, the candidate simply did not pick up on all the different issues. For example, were the goods used for personal use? Nor has the candidate actually successfully discussed whether or not there is a contract for sale of goods between these two parties. So all in all, while this answer once again reaches the correct conclusion, it omits some of the issues from its analysis. And now here is a third answer, which I could use as a model of a good answer, in which the candidate would go about to write a very long answer and to substantiate different things asked on the exam. So we see, for instance, that the candidate starts by writing, in order to determine the applicability of the CISG, we have to turn to the scope of application as defined in Article 1 and the exclusion criteria defined in Article 2. And then we see a very good structure. We see a good division between different paragraphs. It's clear to us, even if we just glance at this answer, that in the next paragraph, candidate will talk about the scope of application, and then paragraph after that, they're going to discuss the exclusion criteria. So when it comes to the scope of application, this candidate writes that CISG is applicable to disputes involving a contract of sale of goods, which is concluded between parties with a different place of business. So they tell us the rules, right? But apart from just telling us the rules, here is the key moment. They tell us, in the present case, this is how these rules apply. The parties have entered into a contract for sale of goods on April 1st, when an offer was accepted with no modifications, right? The candidate didn't just tell me there is a contract. The candidate didn't just tell me the rule says that there must be a contract. They actually explained why there is a contract in this place. In this particular case. So this is why the candidate has actually very thoroughly analyzed this first aspect of the case. The candidate also then briefly states that the parties have place of business in contracting states and that CISG is therefore applicable. And then in the next paragraph, we see a discussion on the exclusion criteria. Once again, the candidate picks out a rule which is most relevant for the case in question, starts by saying that most pertinently for this case, CISG does not apply to the sale of goods for personal use, and then immediately follows up by saying, unless the seller neither knew or ought to have known that the goods were bought for such use. And once again, the candidate then links that abstract rule to the present case. In the present case, the CEO purchased shoes for her own personal use. However, there is nothing to suggest that the seller had actual knowledge of these circumstances. Again, the candidate then addresses one specific aspect of this rule and applies it to the case in question. And then the candidate also discusses this constructive knowledge, should they have known, by saying it would be hard to argue under the circumstances of a case that a reasonable seller should have known the intent of the parties to use the goods for such personal use. The long-standing professional commercial relationship between the parties weighs against such finding. Note here also that the candidate doesn't say, I'm 100% sure. They simply explain to us what is likely to happen in the present case. And that once again shows that it's more important for you on the vast majority of your exams to actually analyze the problems than to reach one specific conclusion. And then the candidate simply concludes by saying that CISG is applicable because the parties come from different contracting states, they've entered into a contract of sale of goods, and no exclusion criteria are applicable. So you will notice that actually the last line in that answer, which is very detailed, is essentially identical to the answer that the other two candidates have provided. However, this answer gets the full amount of points because it actually used the law, it actually applied the law to this particular case. And this is actually a skill which you need to develop. You need to be able to take your understanding of the law and then take that understanding of the law and apply it to a particular set of facts. You might think of it in terms of business practice as well and the relevance of your degree. What's the key skill, or what's the key set of skills that a particular lawyer might have? You will, in all likelihood, think that a lawyer should be able to look at your case, your specific case, and then apply the law to your specific case. So these are the skills you are developing when you're preparing for a legal exam. I hear you. You probably are immediately thinking, wait, this answer is way too long. I will not have the time on my final exam to write anything which is even remotely this detailed. How am I going to ever find the time to actually do this? And that's exactly what I would like to talk about now. So how to prepare for the final exam, bearing in mind these things, so the things which we just saw now, as well as bearing in mind how the exam is actually going to be graded.